Okay. Okay, item 6, the consent calendar includes items 6 through 8 relative to business improvement districts in Westchester Town Center, Historic Waterfront, and Panorama City. Any objections to moving forward? Okay, then that would be the recommendation. Let's go to item number 1.
Item number 1 is a CAO and CLA joint report in response to motion Perry Smith relative to mutual fund taxation. This report has also been referred to the Budget and Finance Committee.
Good afternoon. John Wickham with the Office of the Chief Legislative Analyst. Motion Perry Smith asked that the CLA, CAO, with the Office of Finance look at the taxation, business taxation on mutual funds and clarify the application of the tax on that category of businesses and recommend solutions to provide phased-in relief for those businesses. We looked at data from a number of cities across the state. We looked at the taxing system, had a number of conversations with Office of Finance on possible solutions. And we have determined that the course of action as recommended here is to provide tax relief in the liability by reducing that tax rate by a third for the next 3 years, eventually reducing it. Turns out that the tax is charged against the mutual funds as well as the mutual fund managers. So the business tax is being charged in 2 different sectors here. And we're recommending only addressing the mutual funds themselves, that the tax continue on mutual fund managers. And what we've learned in our research is that cities across the state, a number of them have the ability to tax this, but nobody enforces that tax. And so the city of Los Angeles is at a distinct disadvantage in this business area. And what we've also seen from national surveys is that the mutual fund industry itself is under incredible cost pressures and competition. And what's happening is people, when they're seeking mutual funds, are going to those products that have no charges to them. So what's happening here is there are extensive charges that are being passed off to the investors, the people who are participating in the mutual funds, and rather than seeking these products, are going to products that are basically cheaper in a certain context. So in terms of the policy position here and the policy question in front of the council, it's a question of whether we continue a tax on the mutual funds, which are under incredible pressures in this marketplace, and risk the likelihood that they're going to move to an adjacent jurisdiction. It's very easy for them to do these days. Or provide relief in this tax sector.
Okay, we have 3 cards on this issue. Kathy Herndon, or Herndon? Heron. Okay, that's an O. Okay. Go for it.
Good afternoon. My name is Kathy Heron. I'm a Senior Vice President of Capital Research and Management Company, the investment manager for the American Funds. The Capital Group Companies is one of the largest investment management firms in the world, and it's been headquartered here in Los Angeles since 1931. The Capital Group Companies has a long-term commitment to this city. The Capital Group Companies make a substantial contribution to the local economy, including desirable, well-paying jobs for approximately 1,200 employees in 3 Los Angeles locations. Visitors to our offices have spent approximately $65 million per year, and Capital Group contributes more than $5 million each year to local charities. We believe the Capital Group Companies in the aggregate represent the largest single taxpayer of business taxes in the city. In addition to the corporate entities of the Capital Group Companies, the mutual funds managed by Capital in the city also pay city business taxes. I'm here today to speak to you about the business taxes paid by these mutual funds. I'm not asking for relief from any of the more than $10 million a year paid in taxes by the corporate entities. A manager of mutual funds has a fiduciary obligation to act in the best interests of the funds and its shareholders, who are millions of individual investors saving around the country who are saving for education and retirement through the mutual funds. A mutual fund is only a passive pool of securities owned by the fund's investors. It has no employees, it does not own or lease any real property, and it does not typically pay any federal or state income taxes. We're asking this committee to approve an ordinance that would confirm the application to mutual funds of the current exemption in the city code for persons, quote, receiving dividend or interest income from passive activities, close quote. Although we believe this provision of the code was intended to exempt entities such as mutual funds, the city has been applying the tax to funds, and a clarification is needed. Again, I'm not asking for relief for the capital group companies themselves, but only for the mutual funds managed by our company.
Okay, thank you. Marie Ramsey from CD9.
Good afternoon, council members. Marie Rumsey here on behalf of Councilwoman Jan Perry, and I am here to support the CLA's recommendations and ask that you do the same. We are looking to make the City of Los Angeles fair and competitive for mutual fund companies, and we think the CLA's recommendations put us in the right direction to do so.
Okay, Beverly Kenworthy from the LA Chamber of Commerce.
Good afternoon, council members. Beverly Kenworthy with the Los Angeles Area Chamber of Commerce. I'd like to echo the comments of the two speakers before me. The Los Angeles Chamber of Commerce does support this tax relief on the mutual funds. We believe this is just another issue that puts LA at a competitive disadvantage with other cities, and we would really like to see this company stay here, and we'd like to see those jobs retained. Thank you very much.
Thank you. Michael Banner from BTAC, Business Tax Advisory Committee. Says general comments.
Good afternoon. Michael Banner. I'm President and CEO of the Los Angeles Local Development Corporation and a member of the BTAC Committee. And I'm here today to really echo two things. One is that we believe this is a step in the right direction, and BTAC originally supported the, I forget what the document was, Councilman Perry's original recommendation on this matter. Since we have gotten the work from the CLA in their report, we think that the ability to do something a little broader is important, and this may be an opportunity to do that. We are meeting this afternoon to go over this matter in greater detail. But what I would say, a fund like a mutual fund, there are other classes of entities in the city that fall into this same kind of category. As an example, my organization, which is a nonprofit organization that drives capital into the distressed communities of the city of LA, has a fund. This fund is supported by investment from financial institutions that want to see charter schools financed, want to see grocery stores done. It is subject to the same kind of tax. So the ability of the city to think a little larger in this context is where I want to sensitize you to. Federal government has a tax credit program, $23 billion. That these tax credits, the investment comes through these fund structures. In order to continue to drive investment into distressed communities, I think taking the load off of these same class of funds, as if you want to take off mutual funds, is going to be an important thing to continue to attract investment for CD7, CD9, CD10, the council districts that have a high propensity of distressed community. And as the resources continue to dwindle.
Council districts randomly.
Beg pardon?
Just picking council districts randomly?
No, those are the ones that I actually do business and have done transactions in. And those are the ones that typically have higher levels of distressed populations, which these tax credits attract the investment for. So I think there's an opportunity to broaden the definition of what would be characterized as a fund versus a business and should not be subject to the gross receipts tax.
What is that saying about the intentions of No, the intentions of the well should not get in the way of the good, or something like that. Yeah, don't let the perfect be the enemy of the good. Thank you. I knew you knew it because I think you said it. But there certainly are probably other similar areas that could be addressed in this matter. But I hesitate to throw things on at the last minute without full consideration. In this particular case, Councilmember Perry has requested that we look specifically at this. The CLA has done that, come back with analysis that the BTAC supported, and I see no reason to hold that matter. On the other hand, I encourage you to continue consideration of those other matters that you believe fit into this category and might also be included, and we welcome a report. So it would be my recommendation to move forward as recommended by the CLA and to take notice of BTAC's comments and ask them to continue consideration for like categories of exemptions.
Well, again, we'll be taking this up under consideration today at a 2:30 meeting. We're hoping that there would be some sensitivity about maybe delaying, but it appears that that's not a viable option till the next Jobs Committee meeting.
This is the second time BTAC has come to us and asked us to delay tax reductions, and I'm beginning to worry about that. And again, in fact, I think when you used that comment, it was when BTAC wanted to stall another delay another matter because it wanted to do something bigger. We got to take what we can get when we get it. And at this point, I think this is, with regard to the specific businesses that would be affected by this, I think it's a good thing to do, and we ought to do it for the good of Los Angeles. To delay it, we can always consider other suggestions, but to delay this would, in fact, it would seem to me you could use this as an argument to support you or others. The fact that we pass it. If we don't pass it, then the bigger you make it, the harder it is to get passed. And
that's greatly appreciated. We are working under our life cycle is going to end shortly, so we're trying to make sure we get as many things to come together as possible when decisions are made.
I thought you signed on as a lifetime commitment.
I'm one of the few people that did. This is my second term on this, so I'm close to 6.5 years in on trying to get business tax reform.
Paul and I may not be here, but you will be here. That is the point.
I appreciate your confidence.
Okay, well, thank you very much. Okay, so that would be my recommendation, Mr. Krikorian.
Yeah, this is a tax policy that never really made any sense to me in the first place. We don't tax individual bank accounts, we tax banks. Why we tax individual mutual funds makes no sense to me when we tax the mutual fund manager. So I think that Councilwoman Perry's approach of essentially a 3-year phase out makes sense in light of our budget realities right now. And I think that we should absolutely continue to look at and have BTAC look at additional ways that we can find similar situations where taxation of a fund may in fact have the economic impact of discouraging a greater opportunity to capture more revenues by retaining those firms here in Los Angeles rather than losing them to other local jurisdictions. So I think we should move forward with this. By the time it gets to council, perhaps BTAC can weigh in with possible amendments to this policy, but we need to move forward on this right away.
Okay, then that would be the order as suggested. Yeah, I called up. Did you miss one?
Do you have the cards?
No, I don't. So that would be the order as stated. Item number 2 is essentially a duplicate motion from Zion Parks. We have no report to consider, but given our position on item number 1, I recommend we note and file item number 2. That will be the order. Item number 3
Item number 3 is a CAO report relative to the evaluation criteria for underwriting services for the city's bond programs.
Good afternoon, Ha To from CEO office. Earlier this year, Budget and Finance requested the CEO office to provide a list of criteria to evaluate the RFQ proposals that we receive for underwriting services. This report lists 8 components in which the selection panel will use to evaluate the proposals. They are,
Excuse me, did you say request for proposals?
yes, a request for qualifications.
Okay, thank you.
Sorry. They are public finance experience relating to the pools they're applying for, the personnel assigned, each team member who plays a role in the city's financing, their underwriting capacity, meaning that if for whatever reason we're unable to sell our bonds, they will underwrite the bonds. They will take it into their inventory. We also will be asking for their registration and licenses. We'll ask for disciplinary actions and any litigation that they're involved in, require them to submit contracting forms. We'll ask for their location to see if they have any local offices in the city of LA. And we'll also ask for corporate citizenship. That involves like their charity donations through scholarships, also if they procure any goods with any minority businesses or women-owned businesses. And in addition to the criteria, we also ask them to provide some lending activities information, but that information won't be used as a criteria to score them. We're just asking it for informational purposes because some firms don't do any commercial retail banking while other firms do.
Okay. Item number 4 of the Budget and Finance Committee report I don't know the date, but it's relative to this item. Instructed the CAO to consider information from 2 pending reports prior to finalizing the new RFQ. The CAO status report regarding firms on the bench and how much work the individual firms have conducted for the city, and the city attorney report regarding the lawsuit filed relative to financial firms that have allegedly exhibited misconduct in investment practices that may have resulted in harm to the city's financial interests. So how are we doing that?
One of our criteria, we do have a section where we ask to see if they have any disciplinary actions or any litigation. We do take that into consideration, but it's just one of the criteria that we do take into consideration.
How do you take it into consideration?
We review if
the criteria, Natalie Broad, CA's office, the criteria does ask them to give us what their litigation is, and if they've been fined recently by the Securities and Exchange Commission or the Municipal Securities Regulation Board, which are the 2 agencies that regulate underwriters. And that's taken into consideration. As far as the city's lawsuit is concerned, the outside council did give a briefing to the city council, I believe in March. And then as far as the second motion was concerned,
What happened?
there was no action taken by the council. There was just a briefing from the outside council to the city council on where we stood in the city's lawsuit against certain firms. And that's The council took no action. It was just an update from the outside attorneys.
You said that you're requesting that information of the applicants, you're not requiring it?
We're requesting the RFQ criteria does ask, will be required to describe any disciplinary action by the Securities and Exchange Commission or any federal or state regulatory body over the past several years. This includes any type of disciplinary action that the firm has had. So we are requesting that.
Including allegations?
It says disciplinary action, investigation, or litigation that could arise but not limited to. Allegations, I don't think that we can ask them for allegations. City attorney's here to answer
That's
that.
the instruction in Budget and Finance Committee.
Correct,
That
but
was approved by the City Council.
I understand, but the city attorney looked at our RFQ and approved the actual language on disciplinary action.
Is there any reason why we couldn't have them list any alleged misconduct?
Alleged in a formally filed lawsuit, not innuendo and newspaper innuendo. I mean, alleged is kind of a squishy word. You mean a filed lawsuit allegation?
No, I'm just reading the Budget and Finance Committee instruction, which was that the CAO consider information regarding firms that have allegedly exhibited misconduct in investment practices that may have resulted in harm to the city's financial practice.
I've consulted with my colleagues, and we believe that it might be possible to ask for the information.
I'm sorry, let me read the preceding fragment. It said, the city attorney report regarding the lawsuit filed relative to financial firms that have allegedly exhibited misconduct. So yes.
The formal allegations. Well, first of all, let me just say that.
Let me repeat my question, because it seems like you're going off on a tangent. My specific question is there anything illegal about us requesting or inserting that into the RFQ?
Okay. Let me just say first that I'm not getting off on a tangent. I just want to respond to something that was discussed earlier, which is to the extent that the City Council had a briefing on the lawsuit in closed session about the details of the lawsuit, it wouldn't be appropriate now here to go down that path, other than recognize that occurred. In terms of requesting whether
Natalie, could you let her answer the question? Go ahead.
It is not inappropriate to ask for firms who have been named in the lawsuit alleging improprieties or whatever, however you want to do it, to indicate that they have been named in the lawsuit. That is a factual, that's factual information.
So back to Natalie. Did we request that information?
Yes, we did. We requested disciplinary action litigation for.
I'm sorry, say again?
Firms will be required to describe any disciplinary action, fines and suspensions, investigations and/or litigation by the SEC or any federal or state or a local agency over the past several years. So we did ask them for that.
Okay. Now, are we requiring it?
Yes, that is a required.
Yes,
Okay. Where does it say that they're required?
in the RFQ itself.
Where does it say that?
It says so on request for qualification process. It lists a statement of qualifications and evaluations, and it states all the things that they're required to provide.
It's also one of the questions in the RFQ.
Yes.
Okay, in the RFQ, okay. Now, in the past, the RFQs were approved by the city council. You've changed that practice on this one.
No, the practice of the CA has always been to come to release the RFQ through the CAO's office, but we came to you this time with a statement of what our evaluation criteria will be.
Also,
Yeah, that's,
also in council, back in December 17th, council instructed us to release the RFQ.
Right, I see that. I see that.
So we went ahead and released our RFQ and also submitted a criteria.
Okay, so with regard to the corporate citizenship, is that information required?
Yes.
Yes.
Okay. Okay, now, what is can you describe the corporate citizenship aspects that were included? in
For
this
the
RFP?
corporate citizenship, we asked them to provide information such as their donations to charity, as if they donate to scholarships, to a local nonprofits.
Is there like a section that describes what they have to, is this it?
Yeah, that's it.
This is what is included?
Yes.
Okay.
For informational purposes.
Oh, it says for informational purposes only. So they're not going to be scored on that?
No, it's the informational purposes only, is only for the lending activities that we're requesting them to provide. But the corporate citizenship regarding to the charitable donations, if they procure any goods with minority businesses, that's required.
Okay, wait, let me be clear on what this means. For informational purposes only, firms will be asked to provide information relating to their lending activities aimed to reinvest in the communities they serve, including retail banking, residential, commercial, or community development lending. That seems to be part of their corporate citizenship evaluation. Why would we make that for information purposes only?
Because that criteria is not applicable to all underwriters. Underwriters and bankers, even though they may have the same corporate name, aren't necessarily the same. The SEC and the Municipal Securities Regulation Board regulates underwriters, while the Office of the Comptroller and the FDIC regulate bankers. And sometimes there's a wall between them. So even though the underwriters may have the same corporate name, they can't report on what the bank is doing, and the bank can't report on what the underwriters are doing. So we conferred with the city attorney, and since it was criteria only applied to one set of bankers, you couldn't really apply it to people who are just underwriters. So, because then you have separate criteria
How is it
for separate types of
criteria?
entities.
How is it separate criteria? If they're not engaged in that business practice, we're not going to score them down.
Well, correct, it just says non-applicable, so we're not requiring them to submit it. But according to the city attorney, we can't use it as
No,
part
it
of
says
the.
for information purposes only. In other words, it will not be
Right, we
rated.
read it, but it's
Won't
not
be
part of the
rated.
rating.
So why have it?
We're trying to take a proactive approach regarding the banking ordinance, since it's in its proposed phase right now.
A proactive would rate it.
But we're gathering the information until there's more instructions or more details to the proposed banking ordinance.
I'm going to have to get you your own mic, so Natalie doesn't push her mic over to you.
That's okay, I'll
whenever
grab it
she
if I
doesn't
need
want-
it.
Whenever she doesn't want to answer the question, she pushes it over to you. I don't understand why we can't have the information. First of all, every bank is different. There's some services they provide and others they don't. So it's taken for granted. If we excluded every aspect of consideration because other banks don't do it, we wouldn't have anything to consider. Because some banks do some things and other banks don't do them. But all in all, we should have the opportunity to consider it. But by making it for information only, they don't have to submit it. Is that not true?
My reading of that would be that they have to submit it, but it wouldn't be taken into consideration in scoring.
So if they didn't submit it, it wouldn't be taken into consideration that they didn't submit it.
Well, I would, I'm not a bank filling out a form, but I would assume that if you were a bank and you could respond to that you would respond, and if you were an underwriting firm that didn't do any of those services, you would just say, we are not responding to this because we don't provide any of those services. But you would respond to the question.
But you're not answering my question. If a bank said, we're not going to we're not going to respond to that because it's for information purposes only, would we be able to exclude them from participation?
Ted Jordan from the City Attorney's Office. I'm not familiar with this particular RFQ or RFP in any process, though. If we ask for information, we can tell the proposers, you must provide all of the information that we've requested. And we can also tell proposers if you fail to provide...
Did we do that?
You can also tell proposers that if you fail to provide this information, your proposal will be deemed non-responsive.
But we already issued the RFQ. I'm asking, did we do that?
I don't know.
Yes.
Where is it done?
Do we require them to?
Answer that information.
Yes.
Yes,
Where is it? I want to...
it's, in the RFQ, it's part of attachment A, where
What
we,
does it say in attachment A? Can I have a copy?
I don't have it.
I don't know.
First of all, I don't understand why we're not rating it, but
When we were in Budget and Finance with the report regarding the criteria, Budget and Finance also instructed us to put in the lending information and to collect it on an informational basis only as well.
it's nice. I'm not understanding why we have to do it on informational purposes. Your explanation that some banks do and some don't doesn't explain it to me.
It's the,
How are we going to know whether these are good players that are reinvesting their money in our communities if we don't require them to do it for rating purposes? We still gonna let people who are ripping off the people of Los Angeles rip off the people of Los Angeles? Are we gonna put some teeth into this thing?
If I may add, again, not familiar with the particulars of this, just in the contracting process in general. If you have a criteria, imagine it's worth 10% of the total score. Total score, if you got a perfect score, is 100 points. So if you have a criteria that is, say, worth 10 points, for example, and that criteria is these factors that you are asking about. And because not all folks that are going to be doing this sort of investment banking, the underwriting services, not all of those underwriting service providers engage in those business activities because they're not.
So
They don't have a commercial bank.
So
Well,
what?
just hear me out here. If you have, say, a commercial bank that does underwriting, Bank of America, I'm just pulling them out of the air because, you know, they're a big bank. Suppose you do look at that and you give them a score, say 10 points, because they do all of these things that one might describe as being a good citizen. And then you have another equally capable underwriting firm that doesn't have a retail side, and they don't have any activities to report. What do they get? If they get a 0 because they don't have that, now you're really having an uneven playing field for the underwriting services, because you have those banks that have a retail side that can get a score, and other providers don't have a retail
What is
side.
the basis of the law on that? I just don't get it. I totally
The
disagree.
basis of the law-
I totally disagree with you because it happens all the time. As a former grants author for the city of Los Angeles, we do that all the time. In competitions, some people have some things and other people have others. We take into consideration the whole and we make a determination. So you're telling me that people that are applying for these services have nothing to offer of merit relative to corporate citizenship?
What I'm saying is, and again, my knowledge is more general, not this specific RFQ, is that when it's the services that you are seeking for the city, and you have these other unrelated services that someone may provide and someone may not provide, we're trying to rate people on the underwriting activities, the things that we are asking them to provide for the city, not the host of other services that they may provide or they may not provide, depending on their overall business structure. So we're trying to create a level playing field for the services that we're
I think
seeking.
you're creating an unlevel playing field for the people of Los Angeles. How are they going to compete against these banks who foreclose their houses, who are ripping them off, who are involved in national lawsuits, where they're bid rigging and everything else? How are we going to evaluate that if we don't look at their lending practices?
I think that there's two issues here. One is underwriting services and one is banking services. The only thing that this criteria deals with is underwriting services. The fact that some of the subsidiaries do underwriting is what I was trying to explain before, that we understand that there's some allegations against these banks on the banking side that's regulated differently than what's regulated from the underwriting side. And I think that we don't have a disagreement with you. This is purely for underwriting. This is not for banking. The underwriting subsidiaries of these banks cannot by law be involved with the banking side of the bank. For example, Bank of America has a subsidiary called Bank of America Securities. All they do is underwriting. They don't get involved with the banking side. So our problem is trying to fit into the criteria information on their lending activities within what they do for underwriting. And
The amazing thing to me is that you actually believe that.
I don't believe that. The SEC and the Office of the Comptroller is the one that believes that. I don't regulate federal banks. The government, the federal government does.
But we decide where to invest our money.
And I agree with you, and there can
Good
be,
players or bad players.
and I agree, and the council
But we
can
cannot
instruct
make-
us.
We cannot make those determinations if you are excluding information from the process.
If the council instructs us to exclude these banks, that is council policy. The council can instruct the CAL's office, whoever you want.
I'm not pointing at anybody. All I'm saying is we want this information.
And we've asked for the information from those who
But you're not
provide this. No, because there's a fairness issue. According to the city attorney, there's a fairness issue.
Let's be fair to these people that ripped us off.
There's three reasons why I believe there's a problem here. The first one was described by City Attorney Ted Jordan, which goes to uniformly applying the same criteria to all applicants. The second issue goes to the division between banking and underwriting. When the lawsuit was first filed, the outside attorneys who represent the city advised us meaning the people who do the financing for the city, and the city generally, that the city could continue to do business with the underwriting components of the banks who were named in the lawsuit. The second element is an appropriate division of responsibility between underwriting and banking. The third issue goes to, I think, a constitutional right to due process. If a bank is sued and there are allegations of something in a lawsuit, they're merely allegations, just like it is for any individual who's the object of a lawsuit. And it would violate due process to disqualify someone based only on allegations. And I won't put Mr. Jordan on this hot seat too much, but he and I discussed this third concept before attending
the
that.
principle of caveat emptor, that if somebody is suing you, you don't have to do business with them? Or if somebody is being accused of a crime, you don't have to do business with them? That principle means anything? We just set it aside?
I believe as a matter of due process, yes.
And I believe you're dead wrong. I believe as purchasers of products, we are entitled to consider allegations of impropriety of banking institutions and investment companies relative to whether or not we want to do business with them. Not only do I believe that it's our right, I believe it's our responsibility.
I'll jump on that hot seat. And using the word responsibility, we basically have two methods of awarding contracts: competitive bids and competitive proposals. The rule regarding responsibility is the same. Contractors have to be responsible. We have a contractor responsibility ordinance. The word responsibility is very different than the word responsive. A firm can be deemed to be non-responsible under our code and also under the law, only following a due process hearing. Firms have a right, a due process liberty interest, to compete for government contracts. The government can only deprive them of that right following a hearing. Now, if there is a firm that has been accused of certain improprieties, the city can hold a hearing, evidence can be presented, they will have a chance to defend themselves, and if we find that they have engaged in those kinds of activities that would make them non-responsible, then we can debar them. Once they have been debarred, similar to a lawyer being disbarred, then they can no longer get a city contract for a period of years. But just because a firm has been accused of wrongdoing, just because a firm has been sued, or maybe they have sued us, doesn't make them automatically a non-responsible bidder or proposer.
Mr. Jordan, that's a very good explanation of the law relative to responsiveness and responsibility, but it's not the question asked. The question I'm asking is relative to instruction 4, where it says the CAO consider information regarding 2 pending reports or to finalizing the RFQ. CAO's status report on firms.
I think that we went off on a tangent.
Oh, here, number 3, excuse me. Instruct the CAO to consider relative elements of the proposed responsible banking ordinance and development of the RFQ.
Yeah, and I think there's a misunderstanding on what we're saying. We have asked for this information from the banks, and they are giving it to us. The question, I think, is, and we are looking at that information. What we have been advised that we can't do.
But it's not being rated.
Well, and that's the point, that we can look at it and we can take it into just like we take into consideration.
How do you take something into consideration?
I want to finish I'm sorry. We just like we take into consideration the good faith effort for affirmative action, because under 209 we can't give them points anymore for affirmative action, but we put in a good faith effort and we take that into consideration without rating them. We're following the same example as that. We're following the example of we're taking it into consideration, but we can't score them 3 points for that, because De La Rosa or Siebert would get 0 points for that. And that's
Excuse me. Affirmative action per se is illegal in the state of California.
Correct.
This is
but
not,
we can take into account good faith effort.
This is not illegal.
No, but the advice that we have been given has to do with this due process issues. How can we give 2 points for good, fair lending when other underwriters don't get points for that? So De La Rosa, Siebert, Loop, all the mid to smaller level underwriters, their score would actually be lower than some of the banks that do have good lending practices.
Horrible assumption. A horrible assumption.
Well,
what I said, and I'll repeat, you take a holistic approach. You look at all their corporate citizenship, whatever they have to offer. You take into consideration the fact they don't do this kind of business, but you give it a score. And frankly, I believe those investment firms that you just offered will compete very well.
Oh, I think they will too.
Excuse me, let me finish my point. Not because they're lending, because they don't lend, but they do other things in the community. I'm not telling you not to score those things. In fact, you are scoring those things.
Right.
So I don't understand why you can't rate it.
I guess the council can instruct us to rate it if that's what they want.
Well, that would be my motion.
Okay, well, that's,
I don't know if they can do that legally, though.
yeah,
That would
that's
be
not
my
my
motion.
decision to make.
And we would like to hear a report from the city attorney as to why that is not legal.
I guess we will follow through. I must say that we've given an oral report here to that effect.
Well, I'm asking for a full written report, because I don't believe it. I don't believe there's anything illegal about us asking them and rating that information that they provide.
Can I ask a couple clarifying questions? Sure. Chair. I just want to make sure I'm understanding the flow of this conversation. First of all, remind me, I'll come back to the litigation side, but I want to talk about corporate citizenship first. Corporate citizenship information is required to be disclosed. If it's not disclosed, the bid is non-responsive.
Correct.
Correct? Correct. Okay. Corporate citizenship is rated. and bidders will be ranked based on their corporate citizenship, correct?
Yes.
Yes. The one thing that is excluded is lending history, and that is to be included in the bid, but not rated. That one component of corporate citizenship. Is that correct?
Yes.
So the bidder will be in fact ranked on their universe holistically of their corporate citizenship.
No, that's not true. The
Well,
lending-
let
lending
me
is
finish my
excluded.
question,
That's
Mr.
the
Chairman.
number one principle
I
of the
think.
Community Reinvestment Act.
Okay. Is it not correct that their corporate citizenship will be ranked with the exception of the lending part, which must be disclosed?
Yes, that's correct.
But the
Okay.
lending is the most important.
Well, that's a policy decision. That's a policy decision for you and me and the other council members to make, not for them to make.
Well, but the Community Reinvestment Act, it is the central theme of the Community Reinvestment Act, is their lending practices. To not target that is to not do much.
That's a policy decision.
just-
We might
then you're
rank
just
them on
going
their
through all
environmental
the
practices or their
No.
affirmative action practices, their hiring and using women and minority-owned businesses. There's a million providing.
Lending to
There's
minority businesses.
there's many other things.
Partnering with minority business on lending practices.
Okay.
Those are the things that will be excluded here for consideration of rating.
In the criteria for corporate citizenship, there's sub-criterias. For example, donating to scholarships. That is something that could be applied to all the firms.
We're only
But
talking about the lending
But the
practices.
lending practices can't be applied to all the firms.
Okay, so if I could just finish my train of thought. Under with the proposal that, or under what is before us today, that those other areas of corporate citizenship would be considered, the lending practices would not be considered, and your position is that the reason that that component can't be considered is because it would create inequities among those who do the lending and those who do not.
Well, that's one of them, yes.
Okay. Is there, what other reasons are there for excluding that from ranking?
It's not as relevant to the underwriting qualifications as if you're a bank, you might be a super, I mean, I don't know if this is really true, but I mean, if you're a super underwriter, that's what's relevant here. If you're a super or not super bank, it's not relevant to the performance as an underwriter. So there's,
It's not relative that they foreclosed on tens of thousands of homes in Los Angeles? How's that not relevant?
it's not underwriting.
It's relevant.
Well, that's a policy decision, yeah.
And exactly, that's the policy decision that went into us voting for corporate responsibility, which included lending practices. We're dictating the policy, not you.
Correct. At this point, the ordinance wasn't adopted, so in anticipation of the ordinance being adopted, we included the language from the ordinance per the instruction. But as of today, you know, the banks are giving us their information if they have it. If
You're not rating
they.
it. The issue is why you're not rating it.
Well, and I think we.
You think what?
No, I think that's and I said this before, that's a policy consideration. If you instruct us to do that,
That's why I'm moving.
we will.
That's why I'm moving that the CAO be instructed to consider
Right.
it in their ratings.
And our recommendation is, I think, in agreement with the city attorney, that although we feel it's very relevant for the banking services of the city, because it's directly related, that the underwriting services are different than the banking services. Our recommendation would be, you know, obviously not to, because we think overall could hurt the city for underwriting. I'm not talking about banking.
Mr. Krikorian, you have the option to accept my motion or not. In
Well-
any case, you would be my instruction.
Okay. From my view, on this point, it seems that the instruction that had been given to staff was what they complied with in bringing this report back. If there's an additional element that we want to add on to that now, that's an entirely new issue that they're going to have to address and that the council is going to have to address. So, this is coming up at the spur of the moment, so I haven't thought it through enough to be able to say that I think that is a good policy, so I think I would. And let's just move it forward on your instruction, and then we'll consider it in council.
Yeah,
But may I ask another question before we move on from this point? Because I had a question on the litigation part, too, that I'm not sure was fully addressed. The paragraph in the CAO's report to the Budget and Finance Committee that dealt with disciplinary action and litigation, which I think was what you were quoting from, indicates that firms will be required to describe and disclose litigation, as I read this, essentially only litigation that's brought by a securities regulatory body, either the SEC or a federal or state regulatory body for the past several years. It doesn't seem to be anything in here requiring disclosure of other kinds of litigation, class action, civil lawsuits, litigation that may be pending against the city by these firms, any other kind of litigation other than litigation that was brought against that firm by a regulatory body. Is that not the case?
I was only listening to the language that was being read, but there was something read where the word local entity or something was in it. So
When we talk about litigation, we're talking, the people who regulate underwriters are usually federal and state, whereas litigation can be local.
No, I understand. I'm just trying to identify what is actually being required to be disclosed, because this language that's in front of me indicates that the only thing that must be disclosed are federal and state regulatory agencies' litigations against these firms.
Right, and the contractor responsibility questionnaire, that's where the local comes in. It's covered by this section.
Okay.
So that's required as part of the RFP.
And what does that say? What must they disclose?
City Attorney, answer that's not.
I don't have that form in front of me. It's a more general form that all proposers, with very, very few exceptions, are required to fill out on any services contract. So it requires them to disclose litigation in which they were the defendant. And there's several different categories. I can't tell you exactly what they are off the top of my head, but they're somewhat general in nature. It would include lawsuits based on wage violations if there was anything like that. But it's part of the city's standard contract responsibility ordinance questionnaire. If you have a copy of the RFP itself, it should have been part of that.
That's part of the problem.
Yeah. So, but it would require the disclosure of general kinds of litigation that have been brought against the firm. And that's, again, a questionnaire that we pretty much include in all of our requests for bids and requests for proposals.
Right, so they would report it there.
Oh, okay.
Because we're really interested in two things. We're interested in litigation with the city, and then we're interested in any federal SEC or MSRB rule violations.
Right, but so if there's already a general requirement that all bidders and all RFQs disclose litigation pending against them, why then do we need this special further requirement that they disclose SEC and federal and state regulatory litigation against them? Why wouldn't that already be encompassed in the broader category?
Because that deals directly with their roles as underwriters, and it deals with rules that the SEC has on that aren't really lawsuits per se, but they're more, they have certain requirements, like you have to report your bond sales within 15 minutes of when you buy a bond, all right? And if they don't, and that's because of their disclosure requirements. So if they don't do that, then they're fined by the SEC. And we want to know that because they're trading our bonds. That's not necessarily litigation. So there are federal rules that affect.
I don't want to belabor the point, but
Okay.
on the one hand, we're saying here that we're requiring them to disclose litigation that is brought by federal and state regulatory bodies. On the other hand, we're saying, in general, they're required to disclose litigation. So I'm a belts and suspenders kind of guy. I don't mind that. But the concern that I have is that when you specify the one, you run the risk of excluding the others. Inclusio unum est, exclusio alterius, after all.
If I can jump in on that.
You should add a local, okay?
Yeah. The contractor responsibility ordinance, it's there all the time. If they fail to include something there, in sort of the concern that you have is, we've asked for something specific, now they're not going to tell us the more general. They would run the risk of being non-responsive for failure to include that. The specific kinds of allegations from the description that was just read, it should theoretically be covered by the contractor responsibility ordinance questionnaire, but I think if this is the really, really critical information that we want to know about, I think it's not a bad practice to ask for it specifically, lest there be any doubt about what the more general question on the CRO form is going for. So call it belt and suspenders. It's as long as we get both the belt and the suspenders.
Right, as long as we're all clear that all of those forms of litigation must be disclosed so that we aren't taken by surprise by, so then I just want to make sure that that's clear, and I don't have the RFQ in front of me to know that.
Well, the other issue is sometimes regulatory agencies will issue an order or something short of litigation. And so my reading of this, the regulatory stuff, would be that orders and things, I don't work in that area, but things like orders that are not quite litigation would be covered by this.
Yeah, so
And
all litigation plus all other
the regulatory orders.
disciplinary
Yeah,
actions.
right.
Okay.
Okay, getting back to this item number 4, there were 2 reports that were pending. One, the CAO status report regarding firms on the bench and how much work the individual firms have conducted for the city. What was,
We issued that on April 29th.
I don't have a date on this.
Okay. What was the second one?
What is that?
This was information regarding the city's bond financings from July 2008 to November 2010, and this is where we listed, I believe, the 21 bond transactions that we've done over the last, I guess that would be 2.5 years.
Can I ask the Budget and Finance Committee's recommendations that were approved by council, asked the CAO to consider that information? Before doing the RFQ, what considerations would you have to make before doing the RFQ?
We looked at all the firms and I guess how they performed and which firms were used as senior and which were used as co, I guess they wanted us to look at, and that's what we did.
Okay, now, relative to the city attorney report regarding the lawsuit filed relative to financial firms that have allegedly exhibited misconduct and investment practices that may have resulted in harm to the city's financial interest, what was the CAO's consideration of that?
Well, that was, I think, the meeting we had in closed session. We felt that took care of that.
How so?
Did I definitely the city administrative officer is a qualified list? Oh, we haven't done this yet. This is what we're working on now, that when we come back to you with the new recommended qualified list, that we also include a report on whether or not it should exclude those financial institutions that are found to be committing financial wrongdoings. That's going to be part of our report back to you when we come back to you with
So
a
you haven't
qualified
done the
list.
consideration?
That we what?
You haven't done that consideration?
Well, we're in the middle of the process right now.
But you released the RFQ.
Correct, but
This says not to release the RFQ until you do that.
no, that wasn't.
Yes, it does. I'll read it to you. Instruct the CAO to consider information from 2 pending reports prior to finalizing the new RFQ.
Yeah, we don't know where that's. Oh, here it is. Okay, we did the first report on the status, and then the second report was the CAO and how much work you write. We did that. and the city attorney report regarding the lawsuit filed. Those were the two reports, and the city attorney did give that report in closed session, and there was no action taken by the council. Those were the two reports that we thought.
No, you had to consider that report. And you said you're preparing.
Right, and we did, and what came out of that report was, I think what Marilyn talked about, which was the outside counsel had no problem with us.
That's the city attorney's
Right, and there was no instruction from the,
report. This says the CAO needs to consider that.
right?
You said you hadn't finished considering that.
No, I was referring to another,
No, I read it to you.
no, I was reading the motion on item 34B that said for us to come back when we do the
But I
qualified
read it
list.
out loud.
I'm
was
sorry, I
reading,
didn't.
But I was reading something out
Let
loud.
me see, no, it's recording on the front page, how work, and the city attorney report regarding the lawsuit filed, misconduct, assaults and harm to city practices. Trustee to consider it in our own process. We've considered, I guess our response is that we have considered it, and
How did you consider it?
we've looked at the city's overall financial picture and where our letters of credit are and where,
How does that relate to the city attorney's report?
because the city attorney's report dealt, in closed session, dealt with the lawsuit of these firms. And so one of the things that we looked at was it in the city's financial best interest per the lawsuit and per our RFQ process to exclude these firms. And we determined that because of the size of some of our bond issues and the access to the markets that they provide, that it would be in our best interest to include some of those firms as part of our
Did you
process.
put that in a report to city council?
No, because it was an oral report from the city attorney.
Policy consideration? That you decided it was in the city's best interest?
Well, this just instructed us to consider the information.
I know, but you made the determination that it was in the city's best interest because you're making policy now?
No, I'm not making policy. What I'm saying is that after that meeting, there was no instruction, or there has never been any instruction from the council to the CAO's office not to include these firms. So as far as we were concerned, there was no policy instructing us not to consider these firms. And this.
And the city attorney concurred with you on your consideration?
Yes.
I'm not involved in the litigation or any of the closed sessions or any of the lawsuit part.
If you were involved with the consideration that they made? The city attorney?
I might have generally had some discussions. I wasn't a part of the formal RFP preparation process.
RFQ.
Yeah.
So did you work with the CAO on that consideration or not?
Well, I've given advice earlier in this meeting that
In the meeting
just
prior to the RFQ? Was she giving you answers now?
no. I mean, I was aware that they were preparing an RFQ,
RFP.
and
RFQ, I'm sorry.
and and you know, when my advice is sought, I respond. And earlier in
Did you
this,
issue any formal advice with regard to their consideration of what's in the city's best interest?
I could respond to that. I will respond two ways. One is something I said earlier, which is if just because a large number of firms have been sued and no one has yet been proven guilty of something, that as a matter of due process, you can't automatically disqualify a firm just because of allegations. So that's a legal process consideration, and I consider that appropriate legal advice, and we've talked about that earlier. Number two, now what I'm going to say is not really a legal thing. It's more of a city's best interest financial thing, so it's not my responsibility. But I regularly work on bond financings for the city. And the lawsuit, the defendants in the lawsuit are so numerous that again, this is not my official responsibility, but it's my, I concur that it would not be in the city's financial interest to disqualify all the firms that have been sued because of the number of firms
Did anybody
who
make
have
that
been sued.
suggestion?
What?
Did anybody make that suggestion? I haven't heard that suggestion today at all.
Well, I'm answering questions. I was accused earlier of not answering questions, so I'm trying to be very forthcoming.
Whether it's the disqualification issue came up because nobody raised it.
Oh, well, I don't know. No, then perhaps I shouldn't have volunteered that information, but to the extent that the city
What I
does.
did say is that we should rate it.
Okay.
Rate it, R-A-T-E.
Again, as I said, there's a legal issue about whether that's appropriate. And then,
I'd sure like to see the legal opinion on that.
well, I mean, we can further consider it, but as I said,
I've already asked you to do that. I've already asked for a written report as to why we cannot, in your opinion, rate firms under that section of the RFQ for citizenship, the lending issue.
Okay.
But we weren't talking about disqualifying anybody, we were talking about rating them.
Well, then I withdraw my comment.
Okay. Okay, well, I guess I'm very pleased that the Budget and Finance Committee instructed the CAO to consider those items, but frankly, they've considered them and placed them in such a way that they have no substance to give us any ability to add points for those companies that are doing great things in our community and delete points for companies that are screwing our community. Given the radical swings that we have seen in our economy that are directly at the core of these actions, the foreclosure crisis is part and parcel of our economic crisis. I just think we're shirking our responsibility to protect the people of Los Angeles' money and avoid giving it to people who will profiteer off of bad actions. And so my motion will stand that it'll be the direction of the chair of this committee with Paul Fakorian abstaining, that we rate the information relative to
Lending practices?
on page 2 of the CAO's report to Budget and Finance Committee dated March 21st, 2011, under corporate citizenship, that it will not be for information purposes only, but that we rate it. And if we are not able to do so because we've already noticed people, then that we redo the RFQ. That is my instruction. Also, instruct the city attorney to prepare a written report as to why we cannot rate that information. Would you concur on that? Sure. Okay, Mr. Corcoran concurs on that. This isn't easy stuff. I'm not trying to make it difficult on people, particularly city staff, but I absolutely believe that we are rewarding bad corporate players by allowing them to invest the city's money and not even scoring it, not even scoring their actions in the community that are very well known. The President of the United States of America has said publicly, he's admonished these companies specifically and publicly. So we can't score it? It just seems ridiculous to me. And I think we can do far better. So that will be my goal. The what is the status of the RFQ? As Mr. Krikorian said, we got to mind our P's and Q's.
Well, we're in the middle of interviewing firms. The information, just to reiterate, was asked for. So if you do make the decision to score it, then we have that information already. So that won't be a problem to redo the RF. So we're in the middle of the RFQ right now. We'll finish interviews the end of this week. Yes. And then we'll hopefully get a report to you by
Mid-June.
mid-June, because the current list expires.
Mid-July. The current list expires mid-July. We would like to come back in mid-June with our recommendations.
Okay.
Okay, thank you.
Item number 4.
Just for the record, Mr. Chair, you are noting and filing the CEO report with your additional instruction for them to asking the question why they're not reading the information. Okay.
Thank you. Item number 4.
Item number 4 is a CAO report relative to the allocation and identification of American Recovery and Reinvestment Act funds for the Summer Youth Employment Program pursuant to motion Alarcon Garcetti Zine.
Good afternoon, Mr. Chairman, Councilman Kokorian.
This is good news.
Yes, hopefully it is. I'm Jim Clark, Director of Federal Relations and part of the Mayor's ARA team. I wanted to give you just some background information. The reason that we're here today is basically as a result of the fact that we've determined that there is no real federal funding available for summer youth employment. And last summer, we employed over 17,000 youth, and faced with the fact that we would have drastic numbers of unemployed youth that could cause all kinds of problems for us in the city this summer. The Mayor's office, working with CDD, has looked at and scoured to find ways in which we could put additional funding through the council offices and the mayor's budget. I think you've identified close to $2 million that can be used to hire basically 1,000 summer youth. They've reached out to the private sector, working with the chamber, and it looks like right now that we've been able to identify about enough funding for about 5,000 summer youth. The specific resolution that you've asked us to address today is looking at ARA funds, the American Recovery and Reinvestment Act funds, and specifically the Energy Efficiency and Conservation Block Grant funds, to see if we could identify $1 million or more that could be used for summer youth employment. We've also been looking at ARA projects, or all of the projects that we have funded by ARA, sort of I call it equivalent to sort of looking through the couch for any loose change that we can find to help fund this, but we are looking at every program to see if there's any unused funds or any funds that could be redirected toward this. And we're going to continue to do that. We're going to be making a presentation on Friday to the Council Ad Hoc Committee, and we hope to even refine some of that information by then. What we've found, though, too, is that ARA is different, in fact, because there's a lot of restrictions on how the funding can be used. Not only the restrictions on this funding being siloed by various federal agencies and they having their own rules about how it can be used, but there were some broad restrictions regarding ARA in general. And I just want to mention some of these that take into account or that play into our, as we look at this. One is that any contractor that receives more than $2,000 of ARA funding, and let's give you an example, say the California Conservation Corps, that we would be able to utilize them. Any that receives more than $2,000 is subject to the provisions of Davis-Bacon, which creates some extra restrictions to us. Any individual who uses a tool, say a shovel for planting trees, is classified as a mechanic and has to be paid prevailing wage. So, any products that are used by anyone are subject to the Buy American provision. So you got to make sure that that shovel, that it was actually made in America, that somebody is using. In addition to that, DOE has told us, Department of Energy, who oversees this conservation block grant funds, has indicated to us that if we want to make any programmatic changes, that means rather we have approval for using the funding for certain specific projects that we've identified and gotten their approval for. If we want to make any programmatic changes or create a new program for them, it's going to require their approval, which they said could take up to 4 to 5 months to do. Well, if it takes 4 to 5 months, we've defeated the purpose of being able to use these funds for the summer. So that's something. So we have to look at existing programs. Also, if we do anything in an environmental area, it may require us to look at and get their approval for an environmental review about what we're doing with utilizing the funds. Nonetheless, DOE has been supportive, or at least wants to be supportive, in us being able to use some of our EECBG funding for the summer youth program, as long as we are able to stay within the restrictions and guidelines that they have. And I think one of the individuals from CDD is going to come up and show you the binder of all the regulations they have on this, just to give you a sense of it. But I wanted to give you that sort of sense. We are looking, we're very serious about trying to do whatever we can to participate and help out in this. I'm going to go ahead and turn it over to Tyler Munhall with the CAO's office to talk about his specific report. And we also have representatives here from CDD and DWP to join us at the table to talk about what they've been looked at and how we might be able to utilize these funds. Tyler.
Tyler Munhall, CAO. There's not a lot for me to add, except I do want to acknowledge staff at DWP, CDD on helping to bring this together. I think that there are details that need to be worked out on what project the funds can be used for. There is a possibility of using a DWP program that is approved and adding to it and employing youth through that project. The reason that project, which is the, correct me if I'm wrong, DWP, their retrofit or their nonprofit retrofit program, the reason it worked is because the youth would be doing outreach and education. They wouldn't be using tools. So it gets around some of the regulations. DWP needs to look at their capacity for handling that and whether it will serve the program's goals. And so we're in discussions to try and work out how that might look. And I think in ad hoc on Friday, we'll have more, a final recommendation on that. But the report could be approved as it is. It would at least identify these funds and tag them for summer youth. We may, depending on the outcome of our discussions with DWP and CDD, we may have to reappropriate them into different places, but at least the funds would be there and set aside for summer youth.
Since in essence what we are trying to establish is a City of Los Angeles Summer Youth Employment Project that's independent necessarily of the federal Summer Youth Employment Project. So why couldn't you pay Davis-Bacon wages?
We could, yeah, we can meet those restrictions. It just means
Okay,
you've got less youth to buy. No, that's
well,
not.
no. You could have them work fewer hours and have more of them, and they would make just as much money.
Sure.
The main consideration is that we're going to have literally, whereas last year we had over 15,000 young people employed during the summer. This time we're looking at 2,000 without these special considerations.
Well,
So-
I think they're up to 5,000 that they've
No, it's
identified.
only 2,000.
Is that right?
It's
Okay.
5,000 if we're able to use all this money.
Okay.
I believe that's correct. Is that not right, Ms. Gath?
Including the use of the EECBG money, it would bring you up to about 1,900 youth being employed.
Really?
So it's, yeah, it's very few. That's why I say we want to get the maximum employment opportunities for young people as possible. Now, in DWP, do you have any apprentice classifications? What's the lowest level apprentice classification in DWP?
Gretchen Hardison, Daily DWP. We have just brought on 35 utility pre-craft trainees, which I believe is our lowest apprentice trainee class.
Do you have any clericals?
We do have clerical, yes.
Okay.
I
What would be the lowest pay that would qualify for Davis-Bacon?
don't know off the top of my head, but we can get that.
Well, I would ask that you be very open-minded here, and remember, in fact, how many of the summer youth employment workers are typically in clerical-type positions?
I would let Lisa speak to that, but I think generally, predominantly, most of them are.
Most of them are. They're not out there with shovels. I mean, there's some, the clean and green kids, the Conservation Corps, but most of them are working in offices like mine and Paul's.
Right.
And,
The other thing we have to do, though, we have to make sure that the work that they're doing, if we're using ECBG, is related to energy efficiency or conservation. DOE has been good enough, though, to say that conservation could include water conservation as well, too. But it has to tie in somehow to that activity as well, too.
Just as the general manager doesn't use a shovel, but he's doing paperwork all the time. And that's related to energy efficiency. So that's what I mean by being open-minded. I believe that the Energy Department does want to help us with this project, and I believe the others will too if we do it properly. But don't keep chopping off possibilities. The people who does the clerical for the energy efficiency programs now?
The different departments that have allocations
Oh,
of it.
somebody's doing it.
Right.
So there are opportunities, and I would like to see the department get an E for effort. I don't know how I'm going to believe they get an E for effort. If they can't get an E for effort on this, I don't know how we're going to be able to judge them on June 4th. When they start asking for rate increases, and they can't do stuff like this, easy stuff like this. So I think it's incumbent on not just DWP, but all the departments to really work hard to hire as many young people as possible this summer. And yeah, I want to thank Community Development Department for its willingness to manage those programs, even though they're primarily situated in other departments. Anyway, this is good news. I mean, there seems to be an aura of cooperativeness, and it's just a question of how much we can get done in a short period of time to demonstrate that we can run a perfectly qualified program that creates jobs for young people. Okay, so congratulations, and we'll see you on Friday. And we have a little more detail. Do you have something to add?
Yes, I'm sorry, Councilman. We wanted to amend the CAO's report to add additional controller instructions to get the city up to the 1,900 jobs. CDD is asking to add $735,000 in its prior year savings so that an additional 360 kids can be hired immediately while we continue to iron out the details related to the transfer of the $1 million in EECBG. And here are the controller instructions that we would like to add to what the CAO is putting forward.
Councilmember, if I may, this is additional general fund savings that's been identified just recently.
Great.
There is in HCED tomorrow a report from the CAO on the day labor program, and there are 2 day labor sites that are not eligible for CDBG. Because the CAO hasn't had an opportunity to really analyze these funds, it may be better to report back separately on those, depending on what you determine in HCED tomorrow, and there may be other priorities for those general fund savings as well.
What was the specific question? Where to bifurcate what?
Well, if you want a CAO analysis of those funds to direct us to report back separately, we haven't had an opportunity to look at those and analyze, especially in relation to the day labor program.
just thinking whether or not the CIO's analysis will not get in the way of good public policy. I don't know. I'm just, I'm being facetious. I really don't know. We'll why don't we play that one by ear? We'll see tomorrow in ACD. But I appreciate the concern. Yeah, obviously there may be other things that we can use the money for, but actually, I'm not sure what we can do to get the value that we get out of hiring these young people. I mean, it's pretty hard to match, and on short order. So, but we'll see. That's fine. Thank you. Anything else? Okay, we're good. Thank you. Good luck. Item number 5, our last item. I apologize, I didn't know everybody was here for item number 5, but apparently you were.
Mr. Chair, just for a point of clarification, for item number 4, you're approving the CEO report plus the amendment given by the DWP
Yes.
representative. Okay.
Item number 5 is the city clerk report.
Wait, but I did want to make it clear, we wanted to report back, right? Okay, that's fine. Yeah, we want to report back on that one.
On the channel?
Yeah, thank you.
Item number 5 is the city clerk report relative to various actions for the proposed Arts District Business Improvement District.
Good afternoon, Miranda Pastor with the Office of the City Clerk. We have the Arts District Business Improvement District that is up for renewal for the years 2012 through 2016. The Business Improvement District is required to obtain petitions from stakeholders in the district representing 50%. It has done so, and now the city clerk is submitting their management district plan, engineer's report, and ordinance of intention to establish or renew the district for this time period. After the ordinance is approved by the committee and council, the city clerk will mail notices out as well as the ballots out to the stakeholders for a vote. The ordinance will, and the notice will dictate that the public hearing will be held on July 26th of this year. After the public hearing, or during the public hearing, if petitions or protests are received that exceed 50% of the stakeholders, then the bid will not be formed. If such protest is not received, the bid will move forward, and the ballots will be counted after that public hearing. And the following day, generally, the ordinance of establishment is adopted. The stakeholders or the database of assessees is submitted to the county office assessor's office, in which the assessments are placed on the county tax rolls for billing in the next billing cycle for the property taxes.
Okay. Any questions, staff? Okay, we have a number of cards. I believe there's only one in opposition, and the rest are in favor. There's 2 that don't indicate, but I'm just telling you that it's getting late in the day, and maybe you can expedite your comments and try not to repeat yourselves. So we're going to allow you to speak for 1 minute each. Okay. Oh, and we have a representative from CD9.
Good afternoon, Stephanie Magnin Rockwell from the Office of Councilwoman Jan Perry. Here to support moving forward with the Prop 218 hearing today. I know there has been some public records request hearings, but I do believe that the 2 months that we have before the public hearing in council should be a sufficient time period to fulfill that request.
Okay.
Thank you.
First, we have Varis Pilavjian.
Good afternoon, Vahrij Pilavjan. I'm a property owner, developer, investor in downtown Los Angeles. We are in 3 bid districts, the Arts District, the Jewelry District, and the Garment District. I'm here in support of the Arts bid. They do a wonderful job. I'm also the treasurer of the Arts bid. I don't know what else to say. I mean,
That's great.
they do a wonderful job, and
Okay, Estela
I hope you approve it.
Estela
Thank you.
Lopez.
Good afternoon, council members. Thank you for this opportunity. I'm the Executive Director of the Arts District BID, and I'm about to turn a 2-minute speech into a 1-minute speech, so please bear with me. We have done an amazing job in the past 5 years, gentlemen, and during those 5 years we've heard only support and congratulations. But now that we're in renewal, a handful of voices have launched a campaign to discredit our work and our reputation. For months, we have chosen not to respond to their tirades of falsehoods and accusations, but the time has come to respond, and respond we will. All this information is available to you via the city clerk, but for your committee consideration, I'm going to leave with you today in detail information that puts forward our administrative costs, basis for annual assessment increases, our accounting and auditing procedures, our adherence to city reporting requirements and internal controls. Our accounting firm representative is here to answer any questions you may have. Those attacking the integrity of the bid do not have to prove what they are saying are true. By contrast, they have inundated us with California Public Records Act requests. We trust your committee will consider our documented record of service to the Arts District, the integrity with which we have conducted this work, and allow the 218 ballot process to move forward. I respectfully request that from this committee. Thank you very much.
Okay, thank you. Don, I believe it's Steer or Steyer?
Thank you. I'll be very brief for a lawyer this time.
What's your last name?
Steyer.
Steyer, okay.
I just want to clarify a very minor point, and that is that Ms. Velke, who is one of your witnesses here today, I believe, submitted letters to city council members in which reference was made in the letterhead to her employer, Altman Greenberg, and I contacted that office to confirm, and they did confirm that this is a personal matter with her. They did not authorize their name, and they don't have a dog in this fight. Thank you very much.
Okay, Ken Coelho? Coelho.
Ken Coelho with RBZ. I am the accountant that oversees the Central City East Association as well as the Arts District, Downtown Industrial District, South Park, Hollywood Property Owners Association, and a multitude of other bids in the greater Los Angeles area. We also prepare the tax returns and do audits and reviewed financial statements for several of the bids as well. First, I'm here to answer any questions, and also I wanted to comment on the letter that Don Steyer had referred to. In that letter, there's a statement here that 40% of the taxpayers' dollars are going to support exorbitant salaries through the economic development category of the bid. First and foremost, the total salaries of the allocated to the Arts District is $219,141, which represents 18.5% of the total budget. And in the ED and C category, only $28,488, which represents 2.4% of the total budget.
Thank you. Matt Klein?
I'm Matt Klein, property owner from Factory Place Arts Complex, and I'm here to speak in support for the bid. We have a few hundred people living and working in our development, and the bid has really made the streets and community better for our tenants. Tenants feel much safer walking their dogs, walking the area, and with cleaner and safer streets, the business owners who live in our development feel more comfortable to meet and greet clients. From a leasing standpoint, it made our job much easier with a better looking district. And with positive press and feedback, we are seeing new types of businesses and clients relocating from other areas of the city that are now attracted to the Arts BID area. I was here before the BID, and I see all the positive impacts that it's provided today.
Did you type all that into your phone like that?
25 seconds to do the whole thing. You gave me 1 minute, I had to get it right up.
You should have just emailed it.
Howard Klein?
I didn't type it. Hi, I'm Howard Klein, and I am business and property owner in the area and also the chairman of the Arts BID. And I'm here obviously to speak in strong support of the BID. But one thing I wanted to point out quickly is that the BID is a board. There are 17 people on the board, and the people on that board are from our area. And we have monthly meetings. We take input from the board, and our meetings are open to the public if anybody would like to come. So I just wanted to point that out and tell you that I'm a strong supporter. I've seen vast changes in the area, all positive. Our mission is clean and safe, and we've done a fine job on that, as well as community output. So thank you very much.
Thank you. Kathy Charles?
Honorable council members, I am a resident and artist and loft owner at the Biscuit Company Lofts in the Arts District. And I would just, at this point, like to echo Matt Klein and the other Mr. Klein, because it would be just too repetitive to say what I have to say. It's all about what they said. Also, I'm a member of the Board of Directors of ArtShare Los Angeles, and as a nonprofit organization that provides social service programs for the youth of the district, ArtShare is right in the heart of the Arts District and is well aware of the positive impact the bid has had on the safety of our children who participate in our programs and the entire demeanor of the neighborhood in general, and is in full support of the bid. Thank you.
Thank you. Caroline Oak?
Hi, I'm Caroline Oak, and I live own a business at the Biscuit Lofts. I'm here to read a letter from Elizabeth Peterson, President of the Board of Directors of ArtShare, as she could not attend today. Dear Honorable Council members, as president of the nonprofit school known as ArtShare Los Angeles, located at 801 4th Place, and on behalf of our school's Board of Directors, I wanted to be sure to voice our support for the Arts District BID. ArtShare is a nonprofit school which offers young neighborhood artists aged 13 to 24 years old programs in three primary disciplines: dance, theater, and fine arts. As a responsible mentor and supervisor of our community's youth, the maintenance of the Arts District's neighborhood as a safe and clean community is essential to us, and it is because of the dedication and hard work that the Arts District BID has accomplished that our community is safe for our students today. The patrolling blue uniform Arts District BID officers are responsible for the clean and safe Arts Districts that we have today. As proven by the lowered crime rates in the community over the years, the Arts District bid is a vital and important part in keeping our community clean and safe. Thank you.
Thank you. Laura Velke? Ms. Velke, you didn't indicate whether...
Council members, thank you for this opportunity. This is my first time speaking, so please be a little bit patient. I'm here to challenge the petitions submitted to this committee and the validity of the vote that values wealthy developers over small property owners. By its own admission, the bid is based on commercial property. That's their design. The majority of people that live in the district now are actually property owners, and this vote is weighted in favor of those large developers. The vote is based on the size of a property. It doesn't value individual residents accordingly. So what we found was, based on the documentation that was provided to us on Friday by the city clerk, after weeks of trying to get the documentation from them and the bid, and outright refusal from the bid, we found that the majority of votes are coming from a handful of people in this room here. That's it, the percentage weighted. In addition to that, the city put in almost 15.5%. That's unconscionable to us. We don't want them. They have obstructed community development. We've lost businesses. We're just a little tired, and we want someone that's going to reflect the needs of the community rather than the needs of business owners. Thank you.
Thank you. We have your letter.
Sorry?
We have your letter in the file as well.
Right.
Mark Spilo?
Good afternoon, council members. My name is Mark Spilo. I'm a business and property owner in the Arts District of downtown Los Angeles. I run a family business that has been in Los Angeles for almost 70 years and employs approximately 80 people. The formation of the Arts District bid has had a dramatic effect on improving our lives. I no longer see prostitutes, drug deals, and homeless when I look out my office window. Instead, I see blue shirts on bikes regularly patrolling the neighborhood and 20-somethings walking dogs at all times of day or night, something no sensible person would have done just a few years ago in this neighborhood. The bid has unquestionably changed our quality of life for the better. I pay approximately $6,000 a year for the privilege of having the bid in our neighborhood, an expense that is inexpensive for what we receive. In return, we receive a safer, cleaner, and much nicer place to work or live. I now often arrive before daylight and leave after dark without fear. And as one who has been in this neighborhood for 28 years, I can tell you that the greatest reason for this change has been the diligent, hard work of all the people who make up the bid. Thank you.
Jack Richter?
Good afternoon, Council. I'm Jack Richter. I'm the Senior Lead Officer for the Arts District, Little Tokyo, and the eastern half of Skid Row. And I'd just like to comment on the relationship that I personally and our department has had with the BID over the last 5 years. And I've been working in downtown for about 10, and I've seen a dramatic change within that area. And I can tell you that as the Senior Lead Officer, I work on a daily basis with the BID, not only the administrative, but also the staff that's working in the field. And I look forward to working with them in the future. Thank you.
Thank you. Steve Gibson?
Steve Gibson, Urban Place Consulting Group. I'm the bid consultant that facilitated the process to form the bid, at least to this point. And I just wanted to kind of remind you, and I think you pretty well know that the bid process, there are several meetings, board meetings, all that are open. The process itself really is set up to facilitate stakeholder input, property owner input, and then more importantly, the petition process, which we have completed, shows the majority, the weighted majority of property owners supporting this. And next, what we're asking for today is the 218 ballot process to go forward and set the public hearing. And we would urge you to continue the process and allow the property owners to have a vote and see what comes of that process. Thank you.
Thank you. I can't read the last name, but I believe it's Busby. Jeff? Is it Busby?
It's Budby.
Budby, okay.
Budby. Good afternoon. My name is Jack Budby, and I'm the Director of Operations for Spilo Worldwide, and I run about a 50,000 square foot facility with 70 employees, and I'm here in direct support of the bid. Basically, because of the safety of our employees, we are able to retain and recruit great employees in our area, and it's a thriving business, and I directly relate that to the safety of the bid. Thank you.
Thank you. Frank Novak? Frank, you also didn't say whether you're for or against.
Oh, yeah, I'm against. Thank you. My name is Frank Novak. I own Modernica. We're a furniture manufacturer. We employ about 70 people. We're one of the last furniture manufacturers in downtown. And as a business, and I also own lofts on the same street, I can just say that it hasn't improved my business like 1 cent. And, you know, we just to illustrate really quickly how this affects our street, I pay $11,000 in taxes directly to the bid. My street's assessment is around $33,000. We got in a garbage can, and I have seen the blue-shirted guys on the bikes a few times. I know they do occasionally come, but it's just very, like we aren't really getting anything for it, and it's really, not helping us. But my big issue is, why do all the city entities automatically vote yes? They're like outweighing all the no votes that are in the district. And I just wish that the city would be neutral in this vote and let the people really decide, because you have the city voting against the citizens. Thank you very much.
Jonathan, did I say Jonathan Gerald?
Not yet.
I'm sorry, I skipped you.
Thank you, council members. My name is Jonathan Gerald. I'm the Secretary of the Los Angeles River Artists and Business Association and the Secretary of Los Angeles Downtown Arts District Space. One is the 501c4 Community Betterment Association, and the other is a 501c3 Community Arts nonprofit. I'd first like to point out that there is not universal support for the bid in the community, and that there are a lot of misgivings, particularly among young property owners, small business owners, to whom the tax burden seems excessive in a time of economic desperation. The total amount of city or I guess it's publicly owned property, including city, county, and DWP in the Arts District, is 16.3%. That means that the property owners who have organized the bid only need to achieve slightly better than 35% to impose the bid on the rest of the community. This seems not to be a very democratic process. There are concerns about an excessive administrative cost, and before the bid was organized some years ago, community had hoped to achieve a smaller bid. One last point. Over 10 years ago, Laraba organized a community charrette where we established goals for the development of the community, and none of those goals seem to have had any effect on the goals that the bid has pursued, and that's been very disappointing to us. Thank you.
Can I ask the city clerk? First of all, what was the vote?
The petition level was 50.6.
Oh, what's your name? I must have skipped you. I did as well. You submitted a card?
Yes.
You didn't, are you opponents?
Yes.
Did you submit it to a proponent? No, I'm just kidding.
Yes.
What was your name again? Oh, we got one here. I thought I called this person. Yuval Barzimmer? That's you, okay.
Yeah, my name is Yuval Barzimmer. I'm a resident of the neighborhood. I'm also a board member of the Biscuit Lofts. I also own 40 parcels in the current district.
In the bid district?
In the bid district, yeah. The biggest issue I find is not whether the bid is doing a good job or a bad job, whether the executive director is making over $200,000, yes or no. There's a basically process of democracy. This bid was designed to help businesses. It's taxing residential units. There's language in the bid that says that if a place is zoned residential, it should not be part of the assessment. Because most of the projects which are residential are under the mixed-use live-work lofts. They're not really defined as residential, so they basically fall into the category of the businesses. So that's one issue. The other issue is just pure mathematics. I'll just give you the three numbers, and I'm going to leave you the actual. I worked through the sheet of all the votes that voted yes. Out of 1,035 parcels, 361 only voted yes. They managed to get 50.6% only because the city voted 16% of is the weighted value of the city vote. Without exception, the city vote. So if the city wants to impose a tax, there's a legal way to do that. That's not the way the city imposed tax. Thank you.
Yes, city clerk? Oh, wait, there's one, we can't find your card, so just come forward.
Can give you a card after?
Sure. Lock the door, please.
Thank you. I'm fast, better watch out. Hi, I'm Catherine Doran. I am a resident at Biscuit Company Lofts as well as Yuval. There was a meeting, the bid came around to our building and proposed their services to us at an open HOA meeting. It was discussed among homeowners, and the board voted not to be included in the bid. We then, at the beginning of the year, got a piece of paper to vote to be included in the bid or not, with very questionable language. I went through the list of who had voted yes in the building, in the two buildings on our street. There are 225 units, which represent millions of dollars of tax money. In our building, the Biscuit Company Lofts, where there are 105 units, 13 people voted yes. In the toy company across the street, there are 125 units and 8 people voted yes. So I would say that the meeting where the board members discussed and in front of all the homeowners and decided not to be included in the bid would more accurately reflect our community's desire to be part of this bid. And we have been included in the bid despite not wanting to.
Thank you.
All right, thank you.
City Clerk?
I wanted to point out one thing, the LA City parcels, the City of LA parcels total 3.10%, well, sorry, 6.56%, that's including.
Say that again, start over. Say it again.
LA City parcels is 3.10% and LA DWP parcels are 3.86% for a total of 6.56% of city parcels.
Okay.
There are other government parcels in the district, not just city. There are county and MTA parcels as well, and federal.
Okay, okay, who establishes the rules as to who
Business-
can participate?
Property,
Specifically what
State law.
Yeah, what I'm trying to get at is, that allows public entities to participate in the vote.
Prop 218 specifies that government parcels can benefit unless they prove otherwise.
I'm sorry.
So at state,
What is
city
it?
parcels, city parcels benefit. Proposition 218 says that states are not automatically, state or government parcels are not automatically excluded from business improvement districts.
So it's basically whoever pays can vote.
If you're paying an assessment, you have a right to vote. So the city of LA is being assessed, and so we have a right to vote as well as other stakeholders or property owners who have parcels in the district.
Okay, and were the numbers accurate in terms of the stakeholders versus, again, the state defines how the proportionate voting process?
There has not been a vote at this time, only a petition level, and the petition level that we have are in support, 50.66%.
Bare support, okay. But
Weighted support.
weighted support, and so, okay. So at some point, there is a vote?
Right. After the ordinance of intention is adopted, we mail out a notice of public hearing and the ballots together. And they, all stakeholders have a right to vote that ballot, and they can mail it back into us or fax it back into us by the close of the public hearing, which is scheduled to be on the 26th of July.
Okay, well, I have several comments. Number one, the various thresholds and standards that have been created were created by the state of California. The means to correct, if your issue is with that, the means to correct that is to seek new legislation, quite frankly. And secondly, and frankly, I don't like the 50% standard. If my businesses are going to tax themselves, including the public sector, I would want it to be higher than that, at least equivalent to. I've been an advocate for a 50% budget vote, but this is a little different. This is about taxes as opposed to
Assessments.
budget vote.
They're not taxes. Per state law,
I do
they're
support-
assessments.
I would support, something more than 50%, but frankly, the law is already established, so that's not for me to determine. Secondly, the issue of whether the public sector can participate or not, it's one of those things where you're damned if you do and you're damned if you don't. If you don't participate, then everybody's saying, well, oh, you don't pay your fair share, but you expect us to pay. So for those districts that vote, with large majorities, if the public sector didn't participate, they would have to cover, and frankly, some of the public areas tend to be more blighted than some of the other areas, and so if they're not being corrected, it skews the improvement process. But thirdly, I got to say this, as far as I'm concerned, my hands are tied as long as people meet the minimum thresholds, and really, I would do this with the exception of a tremendous outpouring by the council district office who represents the area. Typically, I just support it and move it forward. But I have to say this is a very, very close petition process. I think it's the closest I've ever seen, except without losing. Is that accurate?
We have 50.60% people in support. We don't have petitions against. That doesn't, just because there's 50 in support doesn't mean there's 50 against. There's no vote at this time.
Okay.
The
So
vote,
we don't know. We don't know.
We don't know.
Okay, so it could
The
be-
vote comes on the
They
26th.
They met the minimum threshold to move forward.
Yes, exactly.
To go to ballot.
Yeah. But there have been a significant number of parcels that have expressed a concern, and I would say that that the manager going to have to do something to reach out to those folks, and if this does ultimately pass, ensure that everybody is getting some clear benefit from this, and try to work with those folks who are in opposition. I mean, that's what I would do politically. I think it's highly recommended to the benefit of this organization. So it would be I would support the CLA's recommendations to allow the process to continue. Do you concur?
I do, but I have one quick question.
Yes.
As to the decision by the public entities as to whether or not to approve the petition and then whether or not to vote in favor, how is that decision made, and by what assessment process does in particular the city agencies evaluate the effectiveness of this or any other bid?
Well, with the Los Angeles Department of Water and Power, it goes before their board, and they vote on it. I'm not sure with MTA. I know that
It goes before their board.
Their board also.
And the city, since the city clerk has always been part of the process, the council, when this process was first started, gave the city clerk we are the ones that sign the petitions, and we were instructed to vote yes from the get-go.
So that also happens through a public
Wait,
process.
Always instructed to vote yes, or just in this case?
No, always.
Now, there are
Because it
times
wouldn't go forward if there was a no.
there are times when per Prop 218, if a property were not going to benefit, like for instance, it stipulates that certain parcel zones solely residential are deemed to not benefit. Also, in that, if the city parcel or government parcel is not going to benefit, they can prove that it doesn't benefit.
But that's not the
And we would never put it before you.
Yeah, the question
Right.
is, you wouldn't put it before us? Why?
If it's not going to benefit.
If we would determine, if the clerk were to determine through the process of developing the management district plan and the engineer's report that, for example, there was a parcel where there was a park that was gated and there was no access by the business improvement district, so we determined that they would only benefit by the boundary as opposed to the entire parcel. So we negotiate on behalf of the city and help determine what the benefits are for the city properties. So by the time it gets to you, it's already been evaluated as to whether or not the city will benefit from the services.
For instance, some parcels, or some business improvement districts, one of their main purposes is business marketing. Well, if it's a property like a DWP parcel, what do they call them, charging stations, that's not going to benefit from marketing. And so we would talk to the bid or talk to the engineer who decides which which properties will benefit, and we would say, this property does not have any retail business or anything that you can market because it's a closed facility with transformers and other things. So we would talk to that.
What I'm not understanding is, when you do the petition, is it actually saying we will benefit, or is it saying we support?
We support.
We support.
How can you take a position to support without the council's approval?
Because we were given tacit approval from when the program started. That was the instruction from the council.
So the instruction from the council was that no matter what the bid proposal is, we support it?
The way you put it, it doesn't sound very good, but when the city properties are presumed to benefit, we are to vote yes.
Presumed? Who makes it? But you make that determination?
The engineer makes that determination.
State law requires an engineer's report, and the engineer has to support the assessments. Basically, an engineer looks at the programs and services which are to be provided and looks at the properties that will benefit. And it makes a report of it, which we have, and it's included as a part of our report, makes a report of which parcels will benefit and to the extent why. So it assesses a special benefit.
Let me ask you this. In terms of what people consider when they vote, they consider a lot of things, not just the engineer's report of who would get some benefit out of it. They consider whether it's good for social harmony. They just don't think it's good because my neighbors won't like it, and I don't want this to be burdened. So, I mean, that would seem to be a consideration for the council.
In terms of us voting, that's what you're
You
asking?
can definitely change the process if you'd like. It's a policy decision, and that was given to the city clerk. If you want to take it back, you may have it.
Well, in the end, it is your decision.
Except in this case where the bare majority was reached, it's glaring.
It's not a.
Usually it's not that much.
I'm sorry, it's not about it's not, well.
Well, yeah.
The law requires, 50% petition level, and there's no against. There's no petitions against except for the cards.
I would have to go back in time, and when the Arts District first started, they originally proposed to start under the city ordinance, which only required a 35% ordinance. And the reason, a 35% petition level, because of the socioeconomic status of that particular area. Because of the government waited, they went to the 50% state law as opposed to the city ordinance to try and include more people and include more property owners.
Yeah.
So they do meet the city's law. They could have gone forward with 35% through the city's ordinance, but they chose to do the better thing and do the 50%.
I'm going to allow Mr. Corcoran to finish, but I would like for the city clerk to just report to me directly. You don't have to come to the committee. But I need to understand where the authority for the city clerk to make a unilateral yes decision when the engineering report states that there would be some benefit. I need to understand that. And yes, I might want to reconsider that.
Absolutely.
Yeah, if it were my district and I opposed it, that would put you in a horrible position. And not to mention put me in a horrible position if it's a bare minimum vote.
Well, the council also has the discretion at any point of time to kill it.
Again, it put me in a horrible position. I'd rather just either weigh in, working the council to support the participation in the petition. Maybe there's some bureaucratic reasons why we didn't go that way, but if you could just report to me directly as to where that came from, I'd like to understand.
Yeah, I'm interested in that as well. And I guess just to finish the thought, every public entity that makes the decision to support a bid, at some point or another in that process, there has been a public process, right? So when DWP decides to sign on to this, when Metro does, when whomever does, it goes before their board, it's agendized, it's publicly noticed. There's a process by which the taxpayers of Los Angeles or the business owners within this bid can go to that board and say, you shouldn't vote yes, and here's the reasons why, right?
Correct.
So that's also part of the democratic process here. It's not just the fact that that these are public entities is not depriving businesses of their ability to participate democratically. It is part of the democratic process, right?
Generally, right. The only thing it would do is it would make the process longer. It was for administrative ease and use, but we're happy to revisit it with you and any of your colleagues.
Okay. Okay. Thank you.
Thank you. Okay, then that matter is approved.
Thank you.
Okay, I think we're done with our agenda. I don't have any other public comment cards, right? Thank you for submitting your card, and this meeting is adjourned. Thank you.